But the ED can't ask that. ED can't ask the CBI to investigate Bulan.
No, it is not the offence under PMLA which the CBI will inquire.
Of course they are inquiring. They went there only for that.
You must consider and keep in mind that everything is in relation to that incident.
I'm coming to that.
But I'm making it clear we are not asking that CBI should investigate PMLA offence.
Not
Not
that
PMLA
The offence is committed by the Hon'ble
PMLA
Chief
offence.
Minister
Did I
and
say
others.
PMLA offence? Did I say PMLA offence?
it is quite this particular incident of the Chief Minister.
Where is the scheduled offence?
It is not about scheduled offence.
Then what
It
is
the offence? These are 4 offences which you have registered against them. Yes.
That's a different. Our
No, that is the only thing. They have come.
Well, what is PMLA is a statute which empowers certain officers who are authorized under the statute to investigate. That's the PMLA, nothing more than that. So every officer so authorized is empowered statutorily to investigate an offense. This is true, Malad, of all investigating agencies which are authorized to investigate under the statute. It is true of the code, it is true of CBI, it is true, Malad, under the Drugs Act, NDPS. So there's an authorization by the statute. So fundamentally, there can't be a fundamental right in these officers. No officer has a fundamental right to investigate offenses. This is, unless there's a predicate offense, this ED doesn't come into the picture at all. What does that mean? First, an FIR has to be filed. Then the ED comes into the picture. Otherwise, ED doesn't come into the picture. Now, there's no FIR in this case, right? They have come under 32. Under what provision of law have they come under 32? Neither the statute allows it, nor the Constitution allows it, nor Part 3 allows it. But the purpose, their purpose is not that at all. What they are claiming in the petition is, please ask the CBI to investigate this. But the ED can't ask that. ED can't ask the CBI to investigate Bulan.
No, it is not the offence under PMLA which the CBI will inquire.
Of course they are inquiring. They went there only for that.
You must consider and keep in mind that everything is in relation to that incident.
I'm coming to that.
But I'm making it clear we are not asking that CBI should investigate PMLA offence.
It's not that
Not PMLA
The offence is committed by the Hon'ble
PMLA
Chief
offence.
Minister
Did I
and
say
others.
PMLA offence? Did I say PMLA offence? A scheduled offence.
it is.
You are
Not even scheduled offence.
Once-
Yeah. Anyway, we will.
Let's just hold on. hold
None
on.
of these
Unless
would be
there is a
relevant.
predicate offence, the ED doesn't come into the picture. The ED does.
It is quite this particular incident of the Chief Minister.
Where is the scheduled offence?
It is not about scheduled offence.
Then what
It
is?
the offence? These are 4 offences which you have registered against them. Yes.
That's a different. Our
No, that is the only thing. They have come.
No. Mullahs, yes, the petition. I'm sorry. Then obviously, Mullahs, your lordship has not seen the prayers in the petition. Not that at all.
Let us read again together.
Yes, of course.
It is not for any offence under PMLA which they have come here.
Not PMLA.
Yes.
Not
And you are
PMLA.
showing the entire PMLA Act and
The
the
scheme of the act,
But-
meaning that they have no fundamental right to invest. They have no fundamental right to invest.
You,
But let's see the petition. It's better.
yes. So what we have understood is,
Yes.
on a reading of the petition, is that
Yes.
the officers of the ED are claiming fundamental right where their safety while investigating the offence.
Yes.
That is only an incident of investigating an offence. But their main plea is that while investigating the offence under PMLA,
Yes.
they have been threatened.
Correct.
They have been threatened.
Correct.
And they have committed the offence intimidating it.
Allow me. What's the fundamental right there? They're assuming they have been threatened. What's their fundamental right?
So that they will answer.
I'm sorry. No.
They
I'm
will answer.
asking myself the question. No, Mullahs, what's that fundamental right, Mullahs?
No,
See
we
the
will
BNS.
answer at the end, not now.
Let's see the BNS, Mullahs. Very simple. The answer is here.
Yes.
Kindly see section 221 of the BNS.
No, let us first read the relief.
We'll see, Mullahs, but since your lordship asked me this question, that look, they are wanting that nobody should interfere. The BNS has the answer.
Yes.
BNS obstructing a public servant in discharge of his public duties, functions. That's the answer. Hence,
Now let us read the prayer.
now let's see. Page 40.
Page 46.
Let's see the prayer. Let's be clear, Mullahs. Let's see what they are asking. Issue a writ of, I'm sorry, page 46.
Yes.
Issue a writ of mandamus directing the CBI to register FIRs. Here it is. Validity says nothing. Has nothing to do with CBI. It's here it is. Register, directing the CBI to register an FIR. How can ED ask for that? And investigate the entire incident. in relation to obstruction of ED search conducted on 8/1/26? The answer is in BNS. At both the residential premises of one petition as well as the Office of Indian PSC Consulting Private Limited, described in detail above, including the role of respondent number 2 being the present Chief Minister for whom I am appearing, the Commissioner of Police Calcutta, the Director of General of West Bengal, and all persons acting in concert. So they, Malaj, thwarted the attempts of the ED.
In this clear, where is the scheme of PMLA coming into?
Because they can't ask, ED can't ask the CBI to investigate. This is to be a separate predicate offence.
Well, it's not a predicate offence at all, my dear sir. It is not a
If
predicate
you don't
offence.
mind, unless there is a predicate offence under the code, now under BNS, ED cannot come into the picture. That is settled law.
ED
by
as
this
an
court in
investigative
several-
agency-
ED cannot file a writ petition for their fundamental right. They have no right to file a writ petition to have the CBI lodge an FIR.
Yes.
Power of survey, notwithstanding anything contained in any other provisions of this act, where an authority, and that authority is defined, director, deputy director, assistant director, and all others authorized for us. On the basis of material in his possession has reason to believe, the reason for such belief to be recorded in writing that an offence under 3 has been committed, he may enter the place. So much as the power of survey, that's not a fundamental right, that's a statutory right. Well, he's entitled to do that. No issue on that. But then there is no, we're ad item on that. We're not questioning the power of the authorized person to come and do what they have to do in terms of the statute. The question is they have no fundamental right. That's the issue, Malas, because this is a 32 moved under 32, Malas. Then search and seizure, again, where the director, section 17, where a director or any other officer not below the rank of deputy director authorized by him for the purposes of this section on the basis of information in his possession has reason to believe, the reason for such belief to be recording in writing that any person, that person is 2S, which I read to your lordships, then they can actually search and seize. Again, regulated by law, regulated by the statute, right? Whereas to this extent, it is different from the Code of Criminal Procedure, because the nature of search and seizure under the code is somewhat different. Now, Malas, kindly come to, then they can retain the property, we're not concerned with. Then, Malas, kindly come to section, then 48 I have read to your lordships. Then kindly come to section 49. I read 48 to your lordship, now 49. So the central government may appoint such persons as it thinks fit to be authorities for the purposes of this act. So the power is with the central government to appoint persons under the statute to carry out the purposes of the statute. And to that extent, it's a regulatory statute as well as an investigative statute. Then, section 50. The director shall, for the purposes of section 13, have the same powers that are vested in a civil court under the code while trying a suit in respect to the following matters. Again, power of discovery, enforcement, enforcing the attendance of persons, including officers, of a reporting authority. The reporting authority here are banking authorities. We're not concerned with that. Compelling production of records, receiving evidence or issuing commissions for examination. So your lordships will notice that the entire petition contains that this is the officers who went there under the statute and they wanted some documents. They wanted the production of some documents. Those documents were taken away. That's the tenor. But that's nothing to do with the fundamental right. I don't know how the fundamental right comes into the picture. Where none of these authorities which have these powers under the statute have a fundamental right for this. They have only statutory rights. Now, Millers, kindly see further. Then, Millers, subsection 2. The director, additional director, joint director, deputy director, or assistant director shall have power to summon any person whose attendance he considers necessary, whether to give evidence or to produce any records during the course of an investigation or proceeding under this act. Now, Millers, your lordships put the question to us, if somebody obstructs such a proceeding, what are the remedies? Oh, there are remedies available under the BNS itself. There are remedies available under the law, Millers. The remedy is not a writ petition under 32. Because what are you trying to enforce? Not anybody's fundamental right. These are statutory powers given under the statute, Millers. And it's regulated. Their powers are regulated. Now see further. So give it. All the persons so summoned shall be bound to attend in person or through authorized agents, as such officer may direct, and shall be bound to state the truth upon such subject, any subject respecting which they are examined, or make statements, and produce such documents as may be required. Every proceeding under subsection 2 and 3 shall be deemed to be a judicial proceeding within the meaning of 193 and 228 of the Penal Code, and subject to any rules in this behalf by the central government, any officer referred to in subsection 2 may impound or retain in his custody for such period as he thinks fit any record produced before him in any proceedings under this Act. Then let's kindly come to jurisdiction of authorities is 51. The authorities shall exercise all or any of the powers and perform all or any of the functions conferred on or assigned as the case may be to such authorities by or under this Act. There is no power outside this Act, Mullahs. So which is the fundamental right that they are claiming? Forget about, Mullahs, the larger issue of 131 and the central government and that this doesn't have any corporate personality. Forget that. Under the statute itself, none of these authorized persons have a fundamental right. And if they don't have a fundamental right, certainly the enforcement director doesn't have a fundamental right. The enforcement directorate, Mullahs, has central government appointed these officers. Now, see further, Mullahs. So I was reading, the authority shall exercise all or any of the powers and perform all or any of the functions conferred on or assigned as the case may be to such authorities by or under this Act, all the rules framed thereunder in accordance with such directions as the central government may issue for the exercise of powers and performance of functions by all or any of the authorities. Now, the issuing of the directions or orders referred to in subsection 1, the central government may have regard to any or more of the following: territorial area, classes of persons, classes of cases, and any other criteria specified by the central government. That's also under the Act.